My name is Matthew Bishop, and this is an informative speech for the Speech 1321 class at Tarrant County College in the spring 2019 semester. The Supreme Court has a tendency to create precedents based off the outcomes of the cases that they oversee. This is helpful because the Supreme Court is able to look at old cases and quickly come up with the results for a current case that they're working on based off of the outcomes of those old cases. It also produces a consistency in how they treat different cases that make it to the Supreme Court. The masterpiece Cakeshop versus the Colorado Civil Rights Commission is no different. This precedent discusses whether or not free religious exercise, or really exercising any of your rights, still has dominance over anti-discriminatory laws. So the conflict. In July 2012 in Lakewood, Colorado, Charlie Craig and David Mullins entered the masterpiece Cakeshop to order a custom cake for their wedding. Jack Phillips, the owner of Masterpiece Cakeshop, refused to make the cake for them based off of his religious beliefs. He said that he creates his cakes as a form of art to honor God, and that if he was to create this cake for a same-sex marriage, that it would be a dishonor to God. This is because he is a Christian in his religious beliefs. Christians, along with a few other religions, such as Islam, believe that homosexuality is a sin. And if you were to condone or endorse that behavior, it would be a sin and would be dishonorable to God. So Craig and Mullins filed an official complaint to the Colorado Civil Rights Division. The Colorado Civil Rights Division looked it over and then told them, yes, you have a case here. Go talk to the Office of Administrative Courts. So Craig and Mullins went to the Office of Administrative Courts and they filed another formal complaint, and the courts looked it over and determined that Phillips's actions were in direct violation of the Colorado Anti-Discrimination Act, and that so they ruled in favor of Craig and Mullins and issued a declaration that Phillips needed to create the cake for the wedding. So Phillips went to the Colorado Courts of Appeals. He made the argument that him being forced to create this cake for same-sex weddings violates his free speech and his free religious exercise rights, and that it would be against the Constitution. So the Court of Appeals looked it over, and they ended up agreeing with the original commission and saying that Phillips still needs to make the cake and that he was still in violation of the anti-discriminatory laws of Colorado. Still refusing to accept this, Phillips went to the Supreme Court. He filed an appeal with them. The Supreme Court looked over the case and determined that the Colorado Civil Rights Commission had violated the Free Exercise Clause. This is the Free Religious Exercise Clause, however you'd like to say it, basically saying that forcing him to go against his religious beliefs would be violating his rights. They said that although the freedoms and rights of the homosexual couple are the same as any American, the religious views of Phillips were also a protected form of expression. This was a majority vote. It was 7-2. And just as a timeline, they walked into his cake shop, as I said, in July of 2012. And this Supreme Court, well, not the Supreme Court case, but the Supreme Court came up with their outcome in 2018. So it was a 6-year process from the original request to the end outcome that is not going to be overwritten. So this answers the original question, right? What precedent is set when it comes to free religious exercise versus anti-discrimination laws? And as the Supreme Court stated, free exercise takes precedent over anti-discriminatory laws. The Constitution and the Bill of Rights will take precedent over any laws that a state will make, even if they are good laws, like anti-discriminatory laws. Thanks for watching.